Good evening. This is John Milburn for Laws 12060 Trusts. Tonight we are dealing with week 3 and we're going to go through some of the basics of trust law, have a look at some of the weekly problems, and if you like, consider some of the assessment that we need to do. So if you need to ask a question or you'd like to ask a question or make a comment, please unmute your microphone or use the chat facility, which is at the bottom. I guess the starting point for me is to talk in general terms about the legal obligations. And I'll just invite someone who's got their microphone off to mute their microphone, if you would. It looks like we've got it now. Thanks. In terms of legal obligations, in a simple form, a trust is very basic. And we're all familiar with what a trust means from a young age. I'm going to attempt something, and that is to share my screen to draw some pictures. Please bear with me.
Sorry, John, just while you're sharing the screen,
Okay.
can you just confirm, I think you just said we're talking about week 3. Is that right? Did I hear you correctly?
Yes. Well, weeks 2 and 3 I'm covering.
Okay, sorry, I thought we were just doing 2 tonight. My apologies.
Oh, 2. Yeah, it'll mostly be 2, but thank you, Jason. That's fine. All right, so can you see my screen? And it should be a OneNote page. Can you
Yeah,
see?
got the screen there at the moment, John. Yep, it's got quick notes.
All right. I haven't done this before, but we'll see how it goes. Let's look at what a simple trust is diagrammatically. So let's assume that at an early age, G for grandmother, can you see that? Does it come up as a G? All right, so your grandmother says to your mother, I want to do something for, let's say, for you, and grandmother gives to mother $10. Now, that $10 can be considered legally in a number of different ways. One is it's a gift, another is it's a conditional gift, another is that it's there's a condition subsequent or a condition precedent. So there's a range of different ways to look at it. But in a simple form, as a trust, if the money is given from grandmother to mother for the benefit of you, then we have a simple trust, which is essentially a bare trust. That is, if the intention is for the $10 to remain as $10, ultimately to be given to you when you're older. It probably goes beyond a bare trust and is a form of express trust where the trustee has some legal obligations, and that legal obligation might be to invest the funds and to account to you for the interest and the capital when you, as you're growing up, and assuming you're a child at this stage, and you receive the money, the capital and the interest, when you turn, say, 18 years of age. So that's a very simple trust that we typically use when we're talking about bear with me. I'm doing well with this technology that we use when we're dealing with a simple situation. All right, you can see my son there diving in the background. Any questions about the bare trust or what we mean in that situation? And you can tell that what I'm trying to do is recover the screen. What I've done there is shared the screen on the same screen as I'm working from, whereas normally I share screen to a different screen. Okay, you can see me now? Thank you for bearing with me on that. All right, so that's a simple form of trust where we have the settlor, which is grandmother, we have mum is the trustee, and we have you as the beneficiary. And there might be some rights and obligations attaching to that simple trust. That's a trust which is established through both a declaration and a transfer. Transfer of funds, declaration that these funds are to be held by you for the benefit of your child. So what are the other ways that a trust can be established? And there's really two broad categories here that trusts are established one way or the other. Can you tell me what they are? It's a very cryptic question.
One is via documents and pre-written, or one could be implied.
Yes, but even broader categories than that. And to a degree, I'm getting a little ahead of myself in that I'm touching on resulting and constructive trusts by even asking that question.
Is one a declared trust?
Yes, but again, the declared trust is part of a much broader category of trust.
By direction?
Again, that's a good answer, but part of the broad description that I'm looking to obtain an answer in relation to. All right. So what I'm really trying to... Yes, sorry.
You're not thinking, it's not those three main sort of trusts, the express and the implied and the, I think, is it constructive, the last one?
Yeah, well, constructive...
One a court imposes, I think.
That's it, Jacob. Now you're getting...
Is that a resulting?
Resulting trust.
Yes.
Okay,
so Jacob has just about hit on what I'm looking for here. If we look at a trust which is created by a declaration or by a transfer or by a direction, what's the essential difference between those three compared to constructive or resulting trusts? Jacob just about had it. Angela?
I think that Justice has put it up in the chat saying it's institutional or remedial trust.
Yes. Again, that's a different type of category to the one I'm looking for. Linda?
Is it by the intention they intended to form a trust?
So that's interesting. You're talking about the attention of they. I guess what I'm really getting to is who is the they when we're talking about the three trusts on this one hand and the resulting and constructive on the other?
The settler wanted to form the trust?
The settlor, yeah, that's more in the first category. Jacob?
I was going to just repeat what I said before. I mean, in one circumstance, the court imposes a trust or reads it from the circumstances, and in the others, the parties, whoever they may be, entities, create the trust.
That's it. No, thank you. So, again, very cryptic question. And all your comments were right, but what I was looking for at that stage was what Jacob identified. And the fact is that the first three, declaration, transfer, direction, are all trusts that are created by an individual, a settlor, whereas a resulting trust and a constructive trust are created by operation of law and are made as a result of a court order. In other words, if someone came to you in your legal office and you're a first-year solicitor and said, I want you to create for me a resulting or constructive trust, what's your answer going to be? You're going to go and look for the precedent books, how to create...
Well, only the court can do a constructive trust, can't it?
That's it, Erin. Yes, which is what Jacob was saying. So if you want to really muck around with someone when you become a partner in a law firm and you've got a new solicitor, ask them to draw up a resulting trust for you. And it's a bit like the equivalent of a tradesperson being asked to go out for a what is it? A long wait or a heavy wait? Anyway.
Is it a left-handed screwdriver?
Left-handed screwdriver. Any of those sorts of things. All right.
I can tell that none of you guys are tradesmen because it's a can of grinding sparks.
Okay, a can of grinding sparks. But anyway, so we've got that essential difference. So keep that in mind as we proceed. So as Jacob said, we need a court order when it comes to, say, a constructive trust or a resulting trust. I mean, you can do things that might cause a situation to ultimately lead to that type of order, but you can't create them. Okay, so what's a quist-closed trust? Why is that important?
A quist-closed trust, the intention might only be one-sided.
Yes, true.
And it's to keep interest in property that's handed over to someone else. It's used for a specific purpose only, or the money must be returned.
That's it. I like that. And every time you have a problem in relation to trusts law, at least for me, I'm always thinking in terms of a quist close trust, because I'm wondering whether the condition that was imposed upon the transfer of the funds was such as to make it a specific purpose that might trigger the imposition of a quist close trust in those circumstances. Okay. Can anyone tell me what the facts were of quist close? Who was involved? Barclays was involved, weren't they?
Yeah, I think Barclays tried to hold on to the money that was advanced to the business, I've forgotten who, and they argue, well, no, it was there for a specific purpose,
Okay.
and Barclays couldn't then foreclose on that to try and get what the business owed to them. It was actually owed to the whoever owed them the quist close trust.
Yeah, Rolls
Yeah.
Razor. Yeah,
Yeah.
sorry, Angela.
Yeah, I was going to say Rolls Razor. It was to pay dividends to people, investors, and when that couldn't happen, the banks thought when they were going into receivership, oh, well, righto, we've got money here, we'll use it for what we want. But the whole point was that the bank wasn't allowed to use the money as they wanted.
Yep, that's it. So thank you, Erin. Thank you, Angela. I think those responses are spot on. And as we're speaking, I will try to have a look at the chat line. I see that people are making comments there, and my apologies if I'm missing those, but I'll try and follow up on those. So a quist close trust is something that you need to be right on top of so that you can consider whether the situation that you're dealing with in a legal problem involving trusts is a quist close trust. So as Erin and Angela said, in those circumstances where the funds are paid for a specific purpose and the purpose can't be achieved or it's only partly achieved, then the question is, will that money be held on trust for the original payer until the circumstances have been fulfilled? So just have a look at quist close trusts, if you would. Any questions about that? Now, chat amongst yourselves for a sec, because I'm going to try to share the screen again. And I do the share screen all the time, but tonight's a bit different because I'm trying to share the same screen, not another screen. Does that make sense? So please bear with me while I attempt that process. Can you see my OneNote yet? Probably no. Now we can? That's good? Okay. Now, I'll try to... I did a test run of this and I nailed it. I had it all organised, but who's good at OneNote? Because I'm only just starting this. I'll delete that. Very good. Okay, discretionary trusts. Diagrammatically, this is the way I look at it. We have a settlor who pays some money, and that amount of money might be, let's say, $10 again. Now we'll go $100. So the settlor pays $100. Sorry, my writing's not very neat. And that money is paid to a trustee. So far, a discretionary trust is looking very much like grandma's trust, isn't it? Money's paid from the settlor to the trustee. In this case, it's $100. And the money is paid pursuant to the terms of a trust deed. So let's put it a little bit over here. There's a document called a deed. It's a trust deed, or it's a deed of discretionary trust. And that's what typically lawyers or accountants perhaps will draft, so that the payment of the money is done in accordance with the terms of the trust deed. So when we have a family trust or a discretionary trust, there is a document, a trust deed attached to it. If there wasn't, it'd look a bit like grandmum giving money to mum. So that deed regulates the basis upon which the trustee receives the money and then deals with the money. Typically, in a commercial setting, the settlor kicks off the trust, if I can use that term, with a modest amount, let's say $100. The trustee then goes about undertaking business, which vastly increases the amount of money coming into that trust. So money comes into the trust as a result of the operations of the trustee. So the trustee, for example, might be in business. It might be operating a business, and the owner of the business is the trustee as the trustee for the XYZ family trust. Does that make sense? So the trustee here, T, is running a business using the trust as a vehicle for doing so. And it's generating lots of money. Now, the trustee typically requires the trustee to do something on the 30th of June every year, and that is to distribute the funds in accordance with the terms of the trust deed. And let's assume for the moment that we're talking about an exhaustive trust. That is one where all of the money, which is accumulated by way of income or dividends in the year, must be distributed. The trustee then has a job to do, and the trustee must decide where the money goes. I say decide because this is the nature of a discretionary trust. A discretionary trust is where the trustee has a certain discretion, and that discretion is usually best described as the requirement or the ability to transfer funds to any one of a number of potential beneficiaries. Now, when I say potential beneficiaries, at this level here, the beneficiaries level, we might have 10,000 potential beneficiaries. And the trustee may decide to transfer income to 3 of those 10,000. Typically, in a family trust situation, there might be potentially 10,000 beneficiaries, but in reality, there is family. So where people use this structure in a family situation is that the trustee, which might be mum or dad, or mum and dad, or probably a company that's operated by mum and dad, makes a decision to distribute some money to mum, some money to dad, and some money to the children. Let's say there's 2 children.
Sorry, I have a question, John.
Yes.
Just on that, with those children, my question was, so say the children are in Class C and there are 2 children in Class C, can the trustee in their discretion say, well, I'm only going to give it to one person in Class C, or it has to be everybody in Class C in equal shares?
That's a really good question. It goes back to the terms of the trust deed. Usually a trust deed provides for primary and secondary beneficiaries, and the primary beneficiaries are usually members of the family. Secondary beneficiaries might be more remote members of the family, and tertiary beneficiaries might be even more remote potential beneficiaries, such as charities. But typically, in a family situation, the trustee is unfettered in the exercise of, I'll say it, because quite often it's a company, its discretion. And it can distribute the funds entirely, usually entirely to primary beneficiaries, or entirely to secondary beneficiaries, or a combination of any of those things, and toss in tertiary beneficiaries for good measure as well. So it's usually, when we say discretionary, it's usually a very wide discretion. And the only obligation in real terms is for the trustee to exhaust the income that's been generated through the trust in that particular financial year. In other words, if the second child says, hey, I didn't receive any money, or I didn't receive enough money, the appropriate response, if you're advising the trustee, is, well, that's just too bad, because C2 only has a right to to call upon the trustee to make a decision. C2 can't direct or have a court direct the trustee as to how that decision should be made. And that is the nature of the discretionary trust. I hope that makes some sense. All right, so why do we do this? I'm just going to, let's see how this goes.
Sorry to backtrack a bit there, but I'm just a bit lost. With the discretionary trust, though, the deed would actually, does that give him some direction to the discretion he has to use? Like you said, all the money to be gone on the 30th of June. That would be stated in the deed.
Yes.
And then would it state the discretion with which he's supposed to allocate it? Like he can't, the trustee just doesn't decide, okay, I like you and I don't like you. Is it?
Well, certainly you're right. We always look to the terms of the deed first. And the deed in a typical family situation would be prepared in a way that does give the trustee the extraordinary discretion to distribute the funds as it sees fit, and it need not give reasons for doing so. So, yeah, it can be discriminatory, it can be exclusory, it can be, justified commercially, or it can be outright silly. The only obligation normally in a discretionary trust situation is for the trustee to actually make the decision to distribute to one or more people. So when I talk about it being exhaustive, if, for example, there is $50,000 worth of dividends and interest earned in the discretionary trust in the financial year, then if the deed requires the trustee to do so, then all of that $50,000 must be distributed to someone. Does that answer your question, Linda? Okay.
But John, at the same time, if it's in the deed that if the trustee has discretion not to distribute those funds, then they have the right not to distribute them, don't they?
Yes. So thank you, Erin. What we're looking at there is the difference between the exhaustive and the non-exhaustive discretionary trust. In an exhaustive discretionary trust, all of the income by dividends or interest, etc., or trading income must be distributed. In a non-exhaustive trust, the trustee has a further discretion, and that further discretion is to distribute only part, but not necessarily all of the funds in that particular financial year. Is that what you're getting at, Erin?
Yes, thanks, John.
Thank you. Okay. Any questions on that before I see on the chat facility there might be a few. Yes. Now, Jason, do you want to say something?
Yeah, I would like to put my 2 cents in there, John, but perhaps we might do that at the end of the conclusion. If that's okay.
Yeah, no, that's fine. Thank you very much. Okay. Please remind me once I've stopped. Okay. So that's the basic way in which a discretionary trust will work. Now, why would people do that? Why would you go to all this trouble to set up a discretionary trust? And what are some of the advantages and disadvantages?
Spread the tax liabilities across the members of a family, perhaps, or the beneficiaries. Yeah,
and that's it. I would suggest that's the primary motivation for setting up a discretionary trust. It's a method of minimising tax generally, where, let's say, for example, and there's more to it than this, but let's say mum has other income, working as an architect or whatever. The trustee might say, well, you get nothing because you're already paying a lot of tax. Dad may not have any other income, so the trustee may say, well, we're going to give you X dollars or we're going to give you 70%. You can express it either way. And the two children, well, the first one might be 20 years old and the other one might be 16. So that brings in some extra elements to consider. So with the second child being 16, under 18, it might be limited to a relatively minor amount, which say $500, so it doesn't incur a great deal of additional penalties. There's double tax applies at a certain level, which is quite low. I'm not an accountant, so I won't guess the exact figures. But the child one who's 20 is an adult and has a tax-free threshold if no other income is earned. So that person might get, say, 25%. So, and 5% here. We'll change that to 5%. So that's the way in which the overall thinking is determined. The other, now I'm going to try and stop the share here. Let's see if this works. Can you see me again? It worked? All right. Very good. The other thing that people like to consider with discretionary trusts is asset protection. Thinking, well, if we've got assets and they're in the trust and they're owned by a company which is trustee of a trust, and I go bankrupt, it's going to be harder for a trustee in bankruptcy to attack those assets that are in a trust. And I guess another reason that people do this is to try to protect others, so that if you want a child to have something, but you don't want them to be attacked, you can, as a parent, have it in a family trust and distribute it as you see fit, depending on their circumstances. So if you've got one child who's going through bankruptcy, you may not distribute money to them because the money will filter into the trustee of bankruptcy's account and then to creditors. Or if another is going through a divorce situation, you may not want them to receive the money. It's a little more complicated, of course, if you are the person that you are trying to protect funds from someone else, because then it's more complicated in that trustees in bankruptcy and people like the ATO and others can essentially go behind that corporate veil, can go behind the trust document and attack the assets that are deemed to be yours. These trusts were very popular in the 70s and the 80s, but progressively we found through the Family Law Act, through changes to tax laws, etc., and creditors' laws, that the benefit of discretionary trusts has been eroded. They're still good. There are some other downsides with a discretionary trust. If you've got one of these, then you need to be aware that people that are on Centrelink and potential beneficiaries are able to, or must, must disclose the existence of the trust, and that can complicate their payments, etc. So there's a lot of good reasons to have a discretionary trust, but there's also a lot of things that will create difficulties, if I can use that term.
John, can I just ask, it's probably not a discretionary trust in this instance, but I remember reading somewhere that if a trust is formed, the beneficiaries need not even know they are beneficiaries. So how would a place like Centrelink or the tax department get onto that if the person doesn't even know about it?
Yeah, that's really awkward, because I am sure that there are many people that sign a document to say, yes, I am not a beneficiary or potential beneficiary in a trust, but yet they are. I'm not sure I can answer it any better than that, Erin, unless anyone's got any other thought.
Yeah, I was just wondering where they'd stand, though, in terms of, well, if the ATO or whoever the organisation was that found out they were actually a beneficiary, could they be penalised if they did not know anything about it?
Well,
but wouldn't they have to receive something? In the meantime, they'd have to receive something if the beneficial interest was delayed and didn't start until a later point. Then they'd have to declare it, at which point they became aware of it and received the beneficial interest.
No, that's a really good point, Emma. And what you've identified there is the difference between being a beneficiary and a potential beneficiary. I'm sure that there have been many instances of people who are controlling a discretionary trust who seek to minimise taxation by spreading the income widely, and the money which is allocated to an individual never actually gets to the individual. I can't say that for sure, I'm just speaking anecdotally, but yeah, there are those potential issues, Emma. I think that there might be issues where beneficiaries don't know it even though they have actually received a benefit. However, many people that are potential beneficiaries have not and may not ever receive any benefit from that trust. So I think that's a different category as well. A bit like a crystallisation of their benefit. All right. Okay, let's talk about testamentary trusts. Who knows what's a testamentary trust?
Left in a will.
Yes. And when we talk about a trust established in a will, there are a whole different range of trusts. Can anyone tell me what terms we have for these trusts or what they might be used for?
Then you've got charitable trusts where you can leave money to charities, but there are even conditions on what represents a charitable trust.
Yep. Yeah, by all means, you can leave money in a will to a charity, or create a charitable trust in your will. Yep, that's one option.
I was interested to read about the full secret and half secret trusts that are sometimes prepared and annexed to a will.
Yes. Well, if it's a full secret trust, it probably wouldn't be annexed to a will. Oh, yeah, it might be, but maybe somewhere separate to the will. What's a secret trust and a half secret trust? Anyone?
Be argued that a secret trust is a trust put in place so a partner or future ex-partner doesn't receive any assets or benefit from that trust at all.
Yes, that might be a motivation for it. But what do we mean by a secret trust? Yes,
I was going to say a half secret trust is where the will says that I'm giving such an amount to this person to be held on trust. So you know that the trust exists, but it doesn't say who to. A fully secret trust would be there's no mention of it in the will at all. A separate kind of agreement.
Yep. Or the will may say, look, I leave a half secret trust. Another example, I leave this to this person and they know the basis upon which I'm leaving it to them. You know, that type of half secret. But yeah, the full secret is it's not readily ascertainable and someone needs to provide some evidence to establish what it actually means. Okay, so in a will situation, we've talked about, and when I say a testamentary trust, I'm talking in very sort of broad terms, but there is a specific commercial meaning for testamentary trust. But in a broad sense, testamentary trust is a trust that's created in a will. So we've talked about a charitable trust. We've talked about secret trusts, half secret trusts. They can all be established in a will, so therefore they're testamentary. What other types of trusts can be established in a will? How about just a pretty standard situation where the money or the property is left to the executor or executrix on trust for someone else? So that's a pretty clear. It's essentially a bare trust within the context of a will. So that's another type of trust. Another one is a protective trust, where money is left to the executor. I'm using the male version here. One day we'll just have everyone will be called executor, but the money is left to the executor, who acts also as a trustee for the benefit of the protection of, say, a child or an adult with intellectual disability or lacking capacity. So that's what we call a protective trust. So that'll be set out in the will saying the money's left to you for the benefit of such and such, here are the rules. Okay, the other thing that we can do, and this is what I think of when I talk about a testamentary trust, is you can set up a discretionary trust within your will so that it becomes a testamentary discretionary trust. And the same sort of principles apply as we saw in an inter vivos discretionary trust, only this time, rather than a trust deed, the will itself constitutes the terms of the testamentary discretionary trust. And the same benefits that flow from an inter vivos discretionary trust are available in a testamentary discretionary trust, but probably with a few little bonuses. Again, I won't get into the accounting side of things, but there are generally some tax advantages associated with being a beneficiary under a testamentary discretionary trust as opposed to an inter vivos discretionary trust. I'm not qualified to say any more than that, so I better not get myself into hot water. Okay, does anyone have a problem with that I'm talking about a testamentary discretionary trust? Do you understand what I mean by that now? Okay. So the will is, when you've got a testamentary discretionary trust will, it's actually a thick document. It might be 30 pages, for example. So a very simple will, 1 page, I leave everything to my wife, my husband, my whatever, that's fine. But in a testamentary discretionary trust, what you may find is that the executor, the deceased, the testator, leaves funds to the executor to be distributed into, let's say, 3 discretionary trusts, each one of those 3 to be controlled by an individual, let's say one of the 3 children of the executor. So if the executor's got children A, B, C, the terms of the testamentary discretionary trust would be, I leave everything to my executor to divide my estate into 3 equal shares, where A is the trustee of the A testamentary discretionary trust, B is the trustee of the B discretionary trust, C, so on. Does that make sense? Try not to complicate it too much. But again, there are those things that you might consider. Okay. Can anyone tell me what a unit trust is? What's a unit trust?
To do with superannuation, isn't it? Superannuation funds have units. You actually, your money goes towards units.
Yes, it can be. That's a good idea. Sophie says a fixed trust. Yes. So a fixed trust is a unit trust is a fixed trust. Can be used in superannuation. I'm going to try and draw again. Bear with me. We'll see if we can get this done. Share screen. Go there. Got it. Get rid of this. I'm not very good at this wiping out bit yet. Cleaned up most of it. All right. So a unit trust is where we have this situation. I'm going to consider a situation where we have 2 people who want to join forces in a commercial venture but don't want to be partners per se, and they've got advice to the effect that they should set up a unit trust. In those circumstances, what happens is this. We have overlaying everything, a business or a venture or whatever it might be. And that business is owned by...
John,
yeah.
Are you drawing again?
I am. Can you see me?
We're not getting it. No, we've got your son diving.
Okay. What are you seeing?
Your son diving and then another page up in the corner that says unit trust.
Let me go back. I'm going to try again. Thank you. What can you see now? Did we get that?
Yes.
All good.
Right, all good now? All right, thank you. All right, so we've got a business, and that business is owned by a company. And that company is trustee for a unit trust. And the terms of the unit trust are that there are 2 units, or equal shares or unequal shares of units. So at this level here, we have a trust deed. like we did for the discretionary trust. And the terms of the trust deed, which is a unit trust deed, is a fixed trust where there's so many units here and there's so many units here. And they're fixed. They can be equal, but they don't have to be. So let's say that there is 100 units here and there's 100 units here. The trustee, which is the company, operates the business, generates cash. That cash filters down through the system so that in equal shares, the unit holders receive their entitlement. So that will be the unit holder there, unit holder 1, and that's unit holder 2. Once the money goes into the unit holders, very often that money, the unit holder will very often be and I'm running out of room here, will be a trustee of, you guessed it, a family discretionary trust. So you overlay that same situation that we saw before, where it goes to another trustee, but this time a discretionary trust, where the trustee has the discretion to distribute the money that it received, albeit via the unit trust. I hope that makes some sense.
John, it's not making much sense.
Where
you had on your diagram, I follow you down from business, corporation, trust.
Yes.
That was very similar to your diagram for a discretionary trust.
Yes.
But when we get to the trust with discretionary, they had their discretion in accordance to the deed as to where it went, and they didn't necessarily have to do a set percentage.
That's
but
right.
With this unit trust, it has to do, does it, in the trustee, does it specifically state what he has to do? So no discretion occurs up here,
That's right.
Occurs further down.
That's right. So if you can see where I'm circling now, I've just circled the words unit trust deed. I hope you're looking at the screen that I intend.
Yes. Yeah.
So in that unit trust deed, which is a fixed trust, the obligation on the trustee is to receive the money that's earned and then distribute that money in fixed parcels to the unit holders. Just like, as Erin said before, just like in a superannuation fund. But this is really just a private situation where there's only, say, 2 individuals that are really in control of this company. So the company operates the business, receives money, then must comply with the terms of the unit trust deed, which is a fixed trust, to distribute the money, in this case, equally to the unit holders, because they have the same number of units. So unit holder 1, who has 100 units, will receive the same amount of money from the trustee as unit holder 2. There's no discretion at that stage because the unit trust deed is a fixed trust, and it's only once it's received by the unit holder, who also happens to be in both cases a trustee, that the circumstances change, because the trustees, so the unit holders are trustees of discretionary trusts, and they are subject to individual trust deeds. But these individual trust deeds are discretionary trusts, just like we saw before. The only real difference is that the way in which the trustee of the discretionary trust receives its money is via the unit trust in fixed shares, rather than being directly the owner of the business. So,
John, sorry. Oh, sorry, John. I didn't mean to interrupt you.
No, please.
Yeah, I was just going to say, when it starts getting that complicated, can you answer where is tax paid? Because it's a company, first of all, so it's company company rates. But do each of these trust holders take out tax before that flows on?
Well, I'm not an accountant, so I've got to be a bit careful. But my understanding is that the unit holders will receive the funds, and the amounts will be taxable at that level. But I may stand to be corrected on that. And I really don't want to get into the whole franking credits situation because I'm not at all qualified for that.
No, but John, do you mean, can I just ask, do you mean just about that tax, and we won't get into all that other stuff, but so you were saying those unit holders receive the money and the funds, and then they have to pay tax on that at that end? Yeah.
In fact, I'm really shying away from this now because I'm not qualified on it. Ultimately, the aim would be that the tax is paid right down here at this level. That would be the ultimate aim. So if it can be structured so that the money funnels through and is taxable in the hands of the ultimate recipients, which are these beneficiaries here, that would be the ideal situation. And that's what I think would happen, but I'm not an accountant, so I better not say.
I'm a wee bit confused about that last bit.
I don't want to confuse you. No,
I understand that. I just don't, I mean, when we go back to the trustees, and you said that the trustees are a family discretionary trust.
Yes.
And then we go to a fixed unit trust. I'm just a wee bit confused there. So it becomes it's a fixed unit trust deed, is that right?
Yes, the unit trust deed is a fixed trust. Yeah.
Right. And then the money is distributed to the two holders, the unit holders on each side.
Yep.
And it's fixed. Can you just explain, I'm sorry to be a bit dumb, but what does the fixed actually mean? Does that mean, I don't quite understand what the fixed means. Sorry.
The fixed bit. Okay. Well, the fixed bit is this, that the trustee of the unit trust is under an obligation to distribute the money in fixed proportions.
Okay, I've got it now. Thank you.
That's it. Whereas the trustee at the lower level, the trustees of the discretionary trust, have that wide discretion that we talked about earlier.
Yes, thank you.
Can just distribute wherever they like.
Thank you so much. I missed it. Thank you.
There was a question of, will they get tax credits? Yeah, and again, there may be issues to do with tax credits, but I think properly drafted, it's possible for the money to flow all the way down to the beneficiaries of the family discretionary trust, and it will be taxable in their hands. As I said, that would be the aim anyway.
John, is it possible to have the family discretionary trust? Can they be a fixed trust that says each family holder is to receive 25%? Do they have to be discretionary?
No, they don't have to be discretionary, but it's a choice. But if you've got a discretionary trust, then you won't have a fixed component, at least not for the whole lot. It may be that you can have a hybrid trust where there's a certain fixed component must go to the primary beneficiaries and a certain fixed component must go to the secondary beneficiaries. But usually in practice, a discretionary trust means absolute discretion, wide discretion.
In that model you just drew, we're looking at 3 separate trust deeds. Is that correct?
Yes, that's it. Yep. Right. Unit trust and 2 underlying family unit discretionary trusts. But you don't have to have that model in the sense that you could have a unit trust and one of the unit holders says, I don't want a discretionary trust, I just want the money to come to me. The other unit holder says, I want a family trust. I want all the money that's coming to me to go into my family trust. So that's a choice that the unit holders make. And of course, you can sell your units. So it's kind of an easy way of selling half a business. Instead of having to sort of sell the whole goodwill, etc., you just sell your units, a bit like selling your shares in a company. All right. Now, I've run out of time. Sorry. Do we have any... I had planned to do much more, of course, but do we have any other questions or issues before I stop the recording, ready for the next session? Those of you... Yes, B?
Since we're not going through the questions, will you be able to post the answers? Or,
I was planning... That was the next thing I was going to do. Can I do this? Can I just say this? And I will post some answers. Problem 1.0, which was the Maserati to Ben on the condition that Ben pays my debt to Max. Well, I think that's a conditional trust. Does anyone disagree with that? I think it's a trust. I give my Maserati to Ben on the condition that Ben pays my debt to Max. I say that's a trust, but...
So is it a precedent or subsequent? I put it as a precedent.
Yeah, I would say it's a condition precedent. Yep. Yes, Jacob?
I thought those things were separate. I was looking at the question and thinking, oh, that looks like a trust. But then when you said characterise these dispositions, I thought they were somehow separate, even though the headings said, conditional dispositions and trusts, or contracts and trusts and different things. So I thought they were separate sort of things. So, yeah, okay, that's cool.
Okay. No,
Makes
thanks.
more sense.
How does it differ from an equitable charge? I have no idea what that is.
An equitable charge?
Yes.
An equitable charge gives someone a right to enforce an amount of money, typically, which they say is owed to them. And when we talk about an equitable charge, of course, it's a remedy in equity where they're seeking a declaration or some equitable remedy, such as specific performance, to enforce the charge that they have over the property. And sometimes these things there are very fine lines between these. Okay. Next one, quickly. I give my house in Bundaberg to Jane absolutely, with the hope that she will allow my mother to live there until she dies. Well, I think they're precatory words. I don't think they have any legal or equitable effect. With the hope that she will allow my mother to live there until she dies. I don't think that there's any obligation on Jane. The person giving the property has said it's to Jane absolutely. That's a clue. And the phrase "with the hope," I think, is more an aspirational statement rather than an imperative. So I don't think there is any trust there or any enforceable right. I don't even think it creates an equitable charge. So, and you can see these things layered, as B pointed out. So you've got maybe a trust. If not, you may have something else. You may have a contract. You may have an equitable charge. You may have some other option available to you. Next one, I give $25,000 to Davis to be used for the cost of educating Mary and to be hers absolutely when she attains 21 years. I mean, maybe it looks a little bit like the one above, but I think it's different because there's a specific purpose for which the funds are to be given to Davis. The words used create much more of an imperative. I don't believe that they're precatory words. And the fact that the gift, as it's described, is on the basis that the funds become Mary's absolutely when she's 21, indicates to me that Mary has substantive rights as a beneficiary. I think there's a trust. But I guess part of the purpose in setting these questions is to have you think about these issues and just appreciate that the wording is so fine and just a few words here or there, a bit like the Oxford comma. If you haven't looked at that, have a look at the Oxford comma. Just a comma, a word, a phrase can make such a big difference. And to be honest, there's no right or wrong answer. So just because I say this is what I think doesn't necessarily mean that I'm right.
Sorry, John, for that one, can I just clarify, it's not a bare trust because it has directions other than just holding the property. Okay, thanks.
Yeah, I didn't see it as a bare trust. Number 4, residue of my estate to Francis who may at her absolute discretion give residue to anyone she sees fit, barring herself, Ben and Jane, and if she doesn't dispose of the residue in her lifetime, it becomes Mary's property. Well, I have a concern about whether we have certainty for the beneficiaries here. And it's very, very broad. It's everyone in the world except 3 people. It could be struck down as being uncertain, to be honest. But assuming that, yeah, sorry.
Oh, sorry, John. I was just going to say, we don't know the age of Mary and we don't know how long she's going to live for. If she lives beyond 80 years, there could be repercussions too, couldn't there?
Actually, I hadn't thought about that. Perpetuities, yes. Perpetuities could be an issue there as well. But look, I think, assuming that we can overcome the issue to do with uncertainty of beneficiaries, I think there's enough in it to say it's a trust. I don't think it's an absolute gift. I don't think the words are precatory. I think it's a trust. It's discretionary in nature. It's actually, when we talk about absolute discretion, that obviously implies it's discretionary. There are no impediments there as to the exercise of the discretion, but there is an obligation to do something about distributing the funds, and there's a penalty if you don't. So I think it's a discretionary trust, a form of discretionary trust would be my vote.
So is this a hybrid power? Is it a hybrid power? And it won't offend, it's an exception to the rule against delegation of testamentary capacity.
Yes, and I think there's a few issues here. In pure trust law, I've got some concerns about the certainty of the beneficiaries. And then from an estate planning or succession law perspective, I think you're right, B. I think there might be some issues there to do with the delegation of will-making power. They'd be the...
I actually don't understand the sentence in the book that says a hybrid power will not offend this rule if the disposition includes a gift or a trust in default or appointment. However, if the power is not coupled with a gift or trust over in default, the power will fall foul of the rule against delegation, even if the criteria is certain.
Okay, I probably need a little bit of context there, B. I wonder if I could get you to post that on UCrew and I could have a look at it. Would that be okay?
Yeah, that'd be okay, because it's just totally confusing.
Yeah, no, I understand. Now, here's the good news about trust law. It's the good news about law generally. When it comes to the exam, you can have a completely different view to me and get a 7, get to 100% marks. And that's a freedom that you've got. If you wish to pursue a certain argument, then follow that argument. And tonight even, we've discussed things where people have said, well, maybe this aspect of law or this way of looking at things is relevant. So keep that in mind and give yourself the freedom of knowing that you don't necessarily have to find the right answer. But what I'm looking for is some logic and an argument to support it. And as I say to students in Introduction to Law, we have so many instances in the High Court of a 4-3 split, meaning that even at the very highest level, you've got judges that come to completely different views over the same matters. So it gives us a freedom, doesn't it, to have that same opportunity to argue without necessarily having a right or a wrong answer. Okay. Well, thank you very much for tonight. We will keep at it. We'll make progress, and please ask through UCrew. What I'm going to do is stop recording now, and we'll be joining the next session soon. But I'll just stop the recording. All the best.